In the case 23-2832, Legacy Cares.
This is on the Legacy Cares case. We'll start with the courtroom first.
Good afternoon, Your Honor. Hank Taylor and Bob McCurgan on behalf of the debtor, Legacy Cares.
Thank you.
Good afternoon, Your Honor. Bradley Pack representing Wholesale Floors, LLC, Elite Sports Builder, LLC, RH Dupper Landscaping, Inc., and JFK Electrical Contracting Enterprises. And also with me today at council table is Cynthia Nesselrode from my office, who can be helping with exhibits.
Great, thank you.
Good afternoon, Your Honor. Jennifer Giaimo on behalf of the U.S. trustee, and we also have Larry Watson of our office, who's appearing by Zoom. And in the courtroom, we have the assistant U.S. trustee, Elizabeth Amorosi.
Okay, thank you. Good afternoon, Judge Peter Riggs from Spencer Fane on behalf of UMB Bank. Also in the courtroom is my partner Jessica Gale, also of Spencer Fane, and Charlie Merkel of the Greenberg Traurig law firm, also appearing for UMB. Thank you.
Good afternoon, Your Honor. Zach Farley of Spencer Fane for UMB as well.
Good afternoon, Your Honor. Jordan Krupp of Chelsea, Stang, Zeal, and Jones on behalf of the Official Committee of Unsecured Creditors.
Thank you.
Good afternoon, Lamar Hawkins, counsel for Image, Pace, and Spray Foam.
Thank you.
Good afternoon, Your Honor. Phil Giles on behalf of Kearney Electric.
Your Honor, James Ugaldi for Eastern Funding and Macro Lease Corporation.
Thank you.
Good afternoon, Your Honor. Robert Warnicki for Hayden Companies, LLC.
Thank you.
Your Honor, James Reed, Udall Shumway for RKS Plumbing and Mechanical.
Thank you.
Good afternoon, Your Honor. Patrick Dirksen for Jayco Design and Installations, LLC.
Thanks.
Good afternoon, Your Honor. Chad Scheck-Snyder for Oakland Construction.
Thank you.
Good afternoon, Your Honor. Alan Maida with Burton Cracchiolo on behalf of Pacific Proving, LLC.
Good afternoon, Your Honor. Ben Reeves on behalf of E&K of Phoenix, Inc.
Thank you.
Good afternoon, Your Honor. Warren Stapleton appearing on behalf of Salt River Community Gaming Enterprise, Casino Arizona.
Thank you. Other than the appearance of Mr. Watson on screen, is there anybody else online that would like to make an appearance? I see the name Lucas Hammond. Maybe not. Anybody else like to make an appearance? Patrick Mohan. Anybody else at all that would like to make an appearance that is not in the courtroom?
Yes, Your Honor. Howard Steinberg of Greenberg Traurig, appearing on behalf of UMB Bank.
Thank you. Anyone else?
Good afternoon, Your Honor. This is Brad Husband on behalf of Insight Investments.
I think I heard Brad Cosman, but you were breaking up on me. Is that right, Mr. Cosman?
Yes, thank you. That's me.
Okay, thank you. Anybody else wanting to appear? Mr. Taylor, let's start with you, please.
Thank you, Your Honor. I think when we were last before you, you had asked for an evidentiary hearing to address some discrete issues in connection with the debtor in possession financing motion. We're prepared to put that evidence on. I have two witnesses, Mr. Keith Berman and Mr. Doug Moss, that we're prepared to offer testimony from. There have been some, as you probably have seen in the record, the U.S. trustee filed a supplemental objection. I believe we have, at least for the purposes of this motion, addressed the U.S. trustee's concerns. Among other things, we filed a revised budget that removed some items that are no longer necessary, some positions that are now vacant and not going to be filled. We've also, in that budget, provided some greater disclosure concerning the expenses, concerns that the U.S. trustee had raised. And we filed that revised budget with the court this morning. The other concerns of the U.S. trustee, as I said, I think we have addressed or are addressing. I'll let Ms. Giaimo speak for herself, obviously, but I believe that they are going to not object to approval on a final basis of the DIP motion, at least. But of course, we understand we have an ongoing process and ongoing investigations, and we're happy to assist them in that process. As for the other objecting parties, I think there were a number of, there were a couple of equipment lessors, Inside Investments, Mr. Kosman's client, and National Sports Opportunity Property. SOP is what I call them. We've worked out some language that we've included in the order to make it clear that we're going to be paying them as part of the budget, and that's going to satisfy their objections. And that language has been incorporated into a draft final order, and as well with that order, there is an amendment to the credit agreement that will also we're proposing to be executed. That order and that credit agreement have been circulated by email to the objecting parties. Have not heard back from many people on it. We may not have had an opportunity to fully digest it, but it has been circulated. The amendment to the credit agreement deals largely with concerns that the Unsecured Creditors Committee raised with us on an informal basis. We believe we've addressed those concerns. I think that the Unsecured Creditors Committee is probably in a position today, we believe, to support approval of the DIP financing motion. Again, I'll let Mr. Krupp speak to that himself. The other objections that we received back last month, at the time prior to our last hearing before the court, dealt with some what I will call just concerns from mechanics lien holders dealing with, they didn't want to have a de facto stay of litigation against the fee. We've taken the view that that's no longer an issue because we've removed that to this court, so there's not a stay issue at this point. But at any rate, I believe that the concerns that were raised by those mechanics lien holders, the ones other than Mr. Pack's clients, have been resolved or are resolved in what we're proposing in the form of a final order and the amendment to the DIP credit agreement. So, today I think at this point the main objection is coming from Mr. Pack for Wholesale Floors and his clients. We're prepared to present evidence to the court on the couple of issues that you cited at the last hearing, which was the reasonableness of the DIP loan, as well as the need and benefit to the estate of borrowing post-petition. We have also prepared to present evidence to the court concerning value, as best as we can, of these assets, and we would do that through Mr. Moss. And then we are also prepared to present evidence concerning the issue of whether there was any work done on this property prior to the bank recording its deed of trust. And again, that evidence would be through Mr. Moss. So what we are proposing to do is we have filed in the record on the first day declarations from Mr. Moss and Mr. Berman. We would offer those in as their main part of their direct testimony. I want you to hear from Mr. Berman in particular as to the terms of the DIP loan, as well as the need to keep the park open, because I don't think that is probably adequately explained in his declaration, but he's prepared to do that today. We're also offering Mr. Moss's declaration for the purpose specifically of establishing the facts and the documents that support the borrowing by the debtor under the first tranche of bond proceeds back in 2020, $250 million tranche that is secured by the deed of trust that was recorded on August 20th, 2020. We're offering it that for that purpose, as well as the documents that relate to that, which are Exhibits 1 through 10 of his declaration, Your Honor. Again, I don't think there's really any dispute on those points as far as the borrowing, the fact that the debt was incurred when the deed of trust was recorded. I think those are all undisputed points, but we just want them in the record nonetheless. So that's what I would suggest we do, is if the court would prefer, we're prepared to put Mr. Berman on the stand and testify to those matters.
So when I look at 364D, there's really two things we're primarily talking about today, both of which are the burden of the debtor in possession. Number one is that the debtor was unable to obtain credit otherwise. And then secondly, that there's added protection here. And I've heard you recount who's going to testify as to what, and it seems like you've got those bases covered. And of course, evidence is what I need. So my inclination would be to just go ahead and get started here, unless perhaps Mr. Pack would like to make an opening statement like you just did.
I don't have any opening statement, Your Honor. I think we addressed the legal arguments pretty extensively at the last hearing. There are a couple maybe housekeeping matters concerning exhibits. One, Mr. Taylor and I had both agreed to the admissibility of our respective sets of exhibits. So that would be debtors exhibits 1 through 3 and wholesale floors exhibits 4 through 7. So at this time, I just ask Mr. Taylor can confirm, but I'd ask they be admitted into evidence.
That confirm that, Your Honor.
Okay, great.
Your Honor, if I may, Peter Riggs for UMB Bank. We have not seen Mr. Pack's exhibits. I don't know what his foundation or evidentiary basis are for them. He did not circulate them in advance, and so we object to documents we haven't seen.
Okay, I guess we'll talk about those when we get to them.
Okay, then I guess we'll get to it when we get to the exhibits. The other housekeeping matter that I had was with respect to the debtor's production in camera of documents that we have not seen that purportedly bear on the value of the property. My understanding of the court's ruling at the May 31st hearing was that you had directed the debtor to produce them to your chambers in camera, but you weren't making a ruling on the admissibility of those exhibits. So I don't know if this is the right time for it or not, and you can certainly tell me to sit down if it isn't the right time. But we would object to the court's consideration of any of those exhibits that have not been produced to us and are not, that are, we assume, hearsay and that are not available for us to examine or to cross-examine in connection with a debt financing motion.
So I intend to resolve the motion today on the evidence, and I didn't hear Mr. Taylor say that he intends to admit those as evidence. And while I've seen them, they're not evidence.
Okay. Then I'll let Mr. Taylor call his first witness.
Let's first hear from the UST and the committee. I'd like to hear what they think, and are they going to participate in the evidentiary side of this hearing?
Thank you, Judge. So at the outset, just so that there's no confusion regarding the status of the U.S. trustees' objections to the DIP financing motion, I just want to clarify that we have not fully resolved all of those objections. Mr. Taylor and I have discussed by phone and email that for purposes of today's hearing, the U.S. trustee will not stand in the way of allowing the DIP financing to continue so that the park remains open and operating pending a sale. And some of the specific issues raised by the U.S. trustee and her supplemental objection have been addressed. As Mr. Taylor pointed out, there was a revised budget was filed today that did appear to reflect changes to the original budget. And the debtor has filed a detailed itemization of the expenses set forth in the summary of the DIP budget, and that's definitely helpful. We didn't receive that until yesterday, so we still need adequate time to scrutinize the budget to make sure that all of our concerns that we outlined in our supplemental objection are addressed.
Tell me what you envision, though. It sounds like on the one hand, you're okay with the final order approving the DIP financing to be entered by the court, but what's to happen with your to-come items?
Well, basically what I'm saying, Judge, is that the budget, the U.S. trustee is not agreeing to and signing off and approving that the budgeted items are all reasonable and necessary and appropriate, and that we won't later object to the payment of any of those expenses. All we're saying, and I believe Mr. Taylor, we both agreed that that this was an appropriate position to take, that for today we're fine with the loan going forward, but he understands, or debtor understands, that we are continuing to investigate, and like I said, we're going to look into the revised budget. They've been very helpful in providing us information and communicating with us, but we do reserve the right to investigate and, if necessary at a later point, object to payments that the U.S. trustee determines to be duplicative, unreasonable, unnecessary, or not a benefit to the estate.
So if this final order calls for approval of an attached budget, you want to reserve the right to challenge that budget somewhere down the road.
Challenge the payments made under that budget. Yes, Your Honor. Exactly.
Retroactively or in advance?
Well, what I would say is that we would want definitely, obviously, in advance to be able to object. And as far as retroactive, if there was any expenditures made that were not reasonable or necessary and not a benefit to the estate, then I think that would be open to objection by the U.S. trustee or anybody that's interested in this case.
So if the attached budget is approved but proves later to be unreasonable and you can persuade the court of that, you A, want the opportunity to do so, and B, reserve the flexibility for that order to be revised.
Exactly. Precisely.
What other items are still yet unresolved with UST?
Okay, so, and I do want to point out that our reservation of rights also regarding the budgeted items includes a reservation pertaining to the management fee that's being paid to Elite. Again, we discussed this with Mr. Taylor, and we are planning to continue working with Mr. Taylor and Mr. Bierman of MCA to get clarity regarding the propriety of that fee, but that is something that, again, we are still reviewing.
I mean, that's part of the same thing you just mentioned, which is the budget issues.
Yeah. I just wanted to be clear that did include the Elite management fee. So the one issue regarding the retention of Elite Sports that we raised in our supplemental objection is that, and the U.S. trustee still has concerns about the fact that Elite, as of today, does not appear to be authorized to conduct business in Arizona. I understand from Mr. Taylor, and he sent us the documents showing that within the last week, Elite had filed an application to conduct business in Arizona as a foreign entity under a fictitious name, Elite Sports Group AZ LLC. The last that I looked, that appears to be pending with the Arizona Corporation Commission. And really, what we're concerned about is that this change in the name of how Elite's doing business in Arizona and the failure to get that appropriate authorization until post-petition, we want to make sure that that's not going to cause any problems, for example, with insurance issues. So I think we need to make sure either today by confirmation with the debtor or as soon as possible after today's hearing that there's no possibility of insurance coverage being jeopardized as a result of these lapses. Let's see. We had another objection based on the preservation of third-party claims, but that has been resolved. Mr. Taylor has confirmed that all the estate claims, including claims against insiders, including Mr. Moss and Mr. Larry White, will be preserved. I'm going to ask that we have an opportunity to review any proposed order granting the DIP financing before it's lodged with the court. I know that an order was circulated and I believe sent to the court earlier, about 2 hours ago.
And you haven't seen that yet?
I just saw it. So I haven't even had a chance to look at it. And I spoke with counsel for UMB, and we agreed that he agreed, and I believe all the parties agree, that the U.S. trustee should have an opportunity to review the language of that proposed order before it's uploaded. Another objection that actually was not addressed in the supplemental objection, but was in the omnibus objection, was to the request that UMB be given a super priority lien. That is still an outstanding objection. We don't believe that that should be granted, and that the only lien that UMB should have is a replacement lien. I believe this is an argument made by multiple other creditors. And then just a couple of matters pertaining to disclosure, Your Honor. The credit agreement requires certain reporting obligations by the debtor. Specifically, the debtor is to provide UMB with biweekly and monthly financial reporting and to submit a borrowing certificate in advance of each borrowing date. And in light of the history of this case and in the history of the park itself, I'd ask, and I haven't approached Mr. Taylor with this yet, and I'm not sure if he's open to it, but I'm going to just put it on the record. We were going to ask that those items be filed with the court. I don't see why that would be a problem. These are disclosures that need to be made anyway to the bank, and we would just ask that they be filed under notice of filing biweekly or monthly financial reporting, or notice of filing borrowing certificate, so that all creditors, all interested parties have transparency as to how the money is being spent here.
And the debtor's resisting that so far?
That's what I said. I haven't had an opportunity yet to discuss that with Mr. Taylor, but it was an issue that I thought, going over the credit agreement, that I don't see why it would be a problem, but it is something I'm going to propose, and maybe Mr. Taylor will get up after me and say, we have no problem doing that. It's just a matter of filing it with the court. But we would ask that that be done.
Let's just touch that one, Mr. Taylor. Any problem with that?
I don't. I guess this is also in addition to our monthly operating reports that we already have to file.
I mean, I suppose that if it's the monthly financial reporting, that could be attached to the monthly operating report. But as far as the biweekly reports, those could be filed, and the obviously
biweekly reports attached to the monthly operating report.
Yes, I mean that would be fine if they wanted to do it like that.
In other words, they don't have to do it every time they have a borrowing request.
Yes, that's. Yeah, I should be clear here. I was just wondering if we're talking about, do I have to make 3 or 4 filings every month, or can I just do this in the form of the monthly operating
I'm
report?
trying to ascertain. It
Okay.
sounds like I'm hearing one filing. It's the monthly operating report, and attached to it will be these borrowing requests.
Yes, that would be acceptable to the U.S. trustee.
That's fine with us, Your Honor.
Okay, and so I just for clarification, that will include copies of any borrowing certificates that were submitted in that monthly time period. Okay, and then just one final point. I just want to make sure that it's clear that, as we understand it, the budget, the DIP budget, is not addressing how proceeds under any potential future sale are going to be dispersed. Just want to make sure that that's understood.
Okay. Anybody else from U.S. Trustee that would like to speak? Ms. Amorosi?
No, Your Honor.
Okay. Mr. Watson, did you want to say something? Mr. Watson, can you hear us, and is there something you wanted to add here?
Sorry, Judge. I was trying to find my my right button here. I do not have anything to add, Your Honor. Thank you.
Okay, very good. Thank you. All right, let's hear from Mr. Krupp then.
Thank you, Judge.
Good afternoon again, Your Honor. Jordan Krupp representing the committee. Mr. Taylor did accurately reflect where the committee is holding at this point. Over the last few days, really into last week, I engaged in what I would characterize as really constructive conversations with counsels for both the debtor and for UMB about the committee's, several concerns that the committee had about the relief being sought today. Those conversations continued and resulted this morning in a resolution of all of the committee's concerns with respect to the issues that we raised last week. Those are accurately reflected in the form of order and amendment to the credit agreement that I have seen and did have an opportunity to review. So at this point, the committee stands in support of the approval of the final debtor in possession financing order today. I don't want to gratuitously add to my comments, but I will say that because the committee is in the position of supporting approval of DIP financing today on a final basis, I'm puzzled by Ms. Giamo's comments and the U.S. trustee's position. It sounds, I can't really tell, frankly, whether the United States trustee's office is objecting or not to the entry of a final order today.
The big takeaway I got from Ms. Giamo was not on a super priority basis.
Okay, well, and that was the other thing that I'm used to the term priming. So I think that what she's referring to is when she calls it a super priority lien, she's talking about a priming lien, not a super priority administrative expense. Correct?
I took it to be the lien issue.
Yes, the lien issue. Okay, so it's a 364D lien that is the subject of the U.S. trustee's opposition, yes?
Ms. Giamo, you are talking about the lien itself, not about the administrative priority.
I'm talking about the administrative priority, the super priority lien that that is being worded as such in
But Mr. Krug is distinguishing between an administrative claim on a super priority basis and a lien position and a super priority basis.
All right, I'm talking about the administrative claim portion of that.
But not the lien itself.
We would ask that the lien be only a replacement, Your Honor. And that's what we had put forth in our original objection. That
Replacement to the extent of the use of the cash collateral.
Yes.
But not to the extent of the additional lending.
Exactly. Yes. Yes. And this was in our objection, our original objection. And if after Mr. Krupp speaks, I'm more than happy to address any other concerns he has besides that.
Okay. That's a big one right there, though, Mr. Krupp.
Okay, thank you. I did appreciate the opportunity to clarify that issue. So in any event, I will limit my comments to the committee's position rather than respond to anything that the U.S. trustee has raised. I'm just trying to sort of set my own expectations for today's proceedings. I want to assure the court that it is not my intention to participate in the examination of witnesses, so we can get done here sometime before midnight. And so I will reserve the right to question witnesses if we feel the need to, but at this point, I don't anticipate it at all.
Okay, thank you. Understanding that Mr. Krupp wants me to pick up the pace here, is there any materialman that would like to speak before we hear from the bank? Am I to take it that the materialmen, A, don't want to participate in the evidentiary side of this hearing, or B, are simply satisfied with the form of order that Mr. Taylor has circulated?
Phil Giles, again, Your Honor, for Kearney Electric. I did have a chance to review the form of order, and I discussed this with Mr. Taylor ahead of today's hearing. I just want to point out it does require a correction as far as the challenge period and when it begins. It references the interim orders, but the interim orders is defined as both the first and second interim orders. So we just need some clarity in the language in this final order as to the date the 75-day challenge period actually begins. And the only other objection we have is to the credit amendment, which Mr. Taylor and I had a chance to discuss at the last hearing, using an amendment to resolve Kearney Electric's objection. Within the amendment, and it's on page, apologize, it's on page 2 of the amendment. It's paragraph 4, it's the changes to 8.1L of the credit agreement. There's a parenthetical that reads, but not foreclose on their liens upon any material assets of debtor or the fee interest of the landlord. Again, my client maintains it has a mechanics lien against the actual land owned by the landlord, which is not property of the state. And so we just object to the addition of that clause. Outside of that, we're okay with the form of order in this amendment to the credit agreement.
Thank you. I think at last report, Mr. Hawkins and Mr. Warnicki had a problem with where we're at, but are you okay where we're at now?
I could have yelled this across the room, I would have. What Mr. Giles just said, that's what we agree with, although we're very much in support of what Mr. Pack is raising as well.
Okay.
My client also believes it has an interest in the land, so we agree with Mr. Giles, and I was planning on staying out of Mr. Pack's way. So,
okay.
Come join me.
Let me turn to the bank then. Mr. Riggs, is there something you'd like to offer before we get to the evidence?
Judge, we join in the debtor's comments and encourage the court to grant the motion today. Addressing some of the issues that were just raised before the court. First, with regard to the comments from Kearney Electric. My understanding of that objection, Judge, is that they believe that the bank should not be able to declare an event of default under the credit agreement if any of the material men are successful in foreclosing against the property owner's fee interest in state court. And I think they're concerned about their third-party rights being compromised. And our intention and our reading of the document is that the provision is intended to provide the conditions under which UMB is entitled to pump the brakes and not advance further money. It is not intended to limit third-party rights with regard to their claims against the fee owner. So I would respectfully suggest that the court overrule that objection. As it relates to the U.S. trustees' comments about, I share Mr. Kroop's confusion. I do believe we're talking about a priming lien as the main concern there. The terms of the DIP credit agreement are sort of well established at this point, and everybody's had plenty of time to review them. They're not. I have no authority to amend those terms, and so the decision, I think, before the court is whether to close the park or not. And I think the court will hear testimony today that priming liens under these circumstances are commercially reasonable and quite common. And I would encourage the court to overrule that objection as well.
Thank you. Maybe you can spend a few minutes, Mr. Riggs, in the back of the courtroom talking to Mr. Hawkins and Mr. Warnicki and Mr. Giles about specifically that provision, because it sounds as if maybe it's not as bad as they think it is, based on what you just said.
Okay.
All right.
Could I address that one point, Your Honor? I kind of took Mr. Giles' comments a different way, as they're not relating to any impairment of the mechanics lien holder's third-party rights against Pacific proving the owner of the fee. I know Mr. Giles said he wanted to know when the challenge period under the DIP order would begin, because one of the provisions of their order is if anybody's going to challenge the priority of UMB's liens, they have to do it within a 75-day period. And I don't know if Mr. Giles was, I don't remember whether he was at the May 31st hearing, but I do recall from that hearing that Mr. Riggs said that's not going to apply to any of the mechanics lien holders who are parties to the state court litigation, which, as the court knows, has been removed here, because effectively they've already asserted that challenge to that priority. So unless Mr. Riggs wants to tell me I'm wrong or I misread him, perhaps that might resolve the concern.
So, Mr. Riggs, given that state court lawsuit has been removed here, do we really even need to know when the starting gun goes off, because it's already happening?
I guess we do need clarity on the starting gun for a couple of reasons. First, I think that the parties that have an interest in this case, such as the committee and perhaps others that are not parties to that litigation, may wish to assert a challenge of one form or the other. So
sure, but we're talking about the people who have already made the challenge.
As it relates to them, Judge, if they're going to make a challenge that goes beyond what is contained in their state court claims, they need to do that within the challenge period. If the challenge that they intend to assert is coextensive with what is at issue already in the state court case that has been removed, well, then we think that a separate challenge action is just redundant.
Okay. Then, Mr. Taylor, it's probably not unreasonable to specifically identify a date by which that challenge period begins, because there are some people that haven't made the challenge yet.
We agree with that, Your Honor. I think there is some ambiguity because there were two interim orders entered on two different dates.
So what date are you proposing? When I sign the final order? If I finally sign it?
That's fine with me, but it's really the bank's issue more than mine, Your Honor.
I'm sorry, Judge, what was the question?
The question is, if we're going to specify a start date, when is that start date? When I sign a final order approving the DIP financing?
I think that if I recall correctly, the language of the interim order reads that it would start as of the date of the first interim order. But
that's correct. And that would be the date that we would propose. It continues on with what we've had previously.
In other words, the clock is ticking already.
That's correct, Your Honor.
And one other point of clarity that I just wanted to make very briefly is, to the extent that we have heard, sort of rumblings that the material men intend to seek remand of the lien priority litigation. To the extent that occurs and there isn't a separate challenge action brought in the bankruptcy court, they need to assert whatever challenges they have in the bankruptcy court to the extent that that case is remanded. I think that's only fair as far as our own due process rights here in this court.
I understand what you're saying. All right, Mr. Pack, was there something else you wanted to say before we get started here?
No.
All right, Mr. Taylor, let's call your first witness, please.
Your Honor, I'd call Keith Berman to the stand, please.
Berman, if you come forward and be sworn in, please.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
Berman, can you please state your name for the record?
Yes, Keith Bierman.
Please tell the court how you are currently employed.
I'm a senior managing director at MCA Financial Group Limited here in Phoenix. We're a corporate turnaround and restructuring firm.
How long have you been with MCA Financial, Mr. Berman?
23 years.
And in your work with MCA Financial, can you describe for the court what your work is? It has been at MCA Financial.
Sure. Your Honor, I've run all manner of corporate restructuring and turnaround projects, been a court-appointed receiver over 150 times in various states, various courts, been financial advisor in a number of bankruptcy cases over those years. I also act as an expert witness on issues of interest rates, plan feasibility, 1111B election, all manner of sort of bankruptcy type issues for financial advisors.
Let me ask you specifically, do you have any experience in negotiating or obtaining loans for distressed companies?
I do, yes.
Can you please explain for the court what your experience is in that regard?
Yes. Over the last 23 years, I've been involved with many dozens of refinancing projects, both out of court and in court. Oftentimes I'll get referred into a borrower by a lender in a distressed situation under a forbearance agreement, work with that borrower with the end goal of getting a refinancing done to take the bank out if that's what the bank desires. I also, when I'm retained directly by debtors, both in and out of bankruptcy court, I work, if there's a situation with the bank where they're in default or they need a new lending institution, work with those borrowers very closely to go out in the market, find loans that are going to suit their needs and going to accomplish the objective in many cases, which is taking out the existing bank or providing supplemental financing for the debtor's operations. I've also in bankruptcy court been involved with a number of DIP financings, both obtaining DIP financing, managing DIP financing when it's received, negotiating terms of DIP financing, and sort of assessing what the market is for DIP loans, negotiating the best deals on behalf of my clients.
Baron, just to put a little finer point on it, about approximately how many times have you been involved in negotiating or obtaining loans for distressed companies outside of court or outside of bankruptcy? Let me put it that way.
Over 23 years, more than 75, I would say.
Okay. How many times have you been involved with obtaining or negotiating the terms of a DIP loan in bankruptcy?
At least a dozen, if not more.
In your experience, Mr. Berman, what are the critical factors that lenders look to in underwriting a DIP loan?
Sure. So there's a number, and obviously it's very situationally dependent, depending on the borrower and the situation that we're trying to obtain financing for. But there's things such as collateral, right? What is the collateral? Is there unencumbered collateral? Is there collateral that has a value in excess of the existing liens on the property? That's certainly a really critical factor. Are there owned assets that the debtor has that can be encumbered or can be pledged? Who is the owner? In this case, we have a nonprofit, so there technically isn't an owner per se. It's just a board of directors who are volunteers. Is there an owner who has credit capacity, who can guarantee loans, who has a financial history that a DIP lender can rely on from an underwriting perspective? Also, the performance of the borrower. Has the borrower historically made money or lost money? Are they currently making money or losing money? What is the need for the borrower at the time? How much money do they need for how long of a period of time? Can they service that debt during, let's say, a bankruptcy proceeding based on the plan to operate the business on a go-forward basis? Do they own real estate? Is the real estate owned, and can it be pledged? Can it be liened? Can even a second be given on real estate? In this particular case, we don't have that circumstance because it's a ground lease. So those are just a number of factors that lenders will look to. They'll need to gravitate towards some collateral to be able to make sure that at the end of the day, if they make that loan, they can get repaid, and they will get repaid in full plus the interest that they contracted for in the agreement.
And does litigation or the debtor's involvement in any litigation, is that a factor?
It is a factor. Obviously, if there's litigation, which typically means there's unsettled issues in bankruptcy cases, oftentimes there's unsettled issues with respect to lien priorities. That kind of uncertainty is something lenders do not like. They want to ensure, they essentially underwrite the debtor's plan, right? They underwrite whatever that plan is to get to the end of the case in a DIP loan. And if there's litigation, if there's uncertainty, and the lender can't get comfortable which way that litigation is going to go, and that litigation could potentially hurt their ability to get repaid, it's certainly going to be a negative factor that they're going to consider. They're not going to take the risk of lending into a situation where they don't feel they have some amount of control and some amount of insight and a view into what will likely happen in the case.
When was MCA employed by Legacy Cares, Mr. Berman?
We were initially retained as a Chief Restructuring Officer for Legacy Cares, Inc. In early January of 23.
Please explain to the court what services you provided what services MCA provided to the debtor prior to the bankruptcy.
Sure. So as the CRO, we were responsible for interfacing directly with the board and the management of the debtor, working with the management company at the time, working with all of their employees, working with contractors, vendors, working with UMB as the trustee for the bondholders, basically working with all the parties to resolve a whole host of issues that this park has. Strategic issues, what's the direction of the park? Financial issues, how do we cut the burn as much as possible? How do we get new capital into the park to be able to operate it? How do we deal with these mechanics liens that are outstanding? We negotiated contracts. We put together budgets. We put together projections. We tracked budget to actual. We reported a whole host of financial and non-financial information to a number of parties, including the trustee and its financial advisor. Worked very closely with them. Also worked with legal counsel for the debtor on a number of issues that the debtor was facing, primarily from a business perspective, but how do we restructure a contract to make it more advantageous for the debtor? How do we renegotiate terms of a particular deal so that it's more palatable to the debtor so the debtor has the opportunity to see its way through this process? It was candidly a full-time job. I mean, I had 2 or 3 people in my office basically working full-time on this project because it was so hands-on and there were so many issues that needed to be resolved.
Now, at the time you were employed in January, can you describe, generally speaking, Legacy Care's financial situation?
It wasn't good. It was terrible. Debtor was burning about $1 million a month before debt service, missed its debt service payment, had $300 million worth of bonds outstanding, had a whole bunch of mechanics liens outstanding, was essentially having to borrow money from the trustee and the bondholders, had to borrow new money in order to be able to sustain its operations and just pay its bills in the ordinary course. And at the time that I got involved, the debtor was working with an investment bank to try to raise additional capital, either through some kind of quasi-equity infusion or issuance of new bonds that would be either pari passu or junior to the existing bonds. That was an effort that started even before I got involved in October, I believe it was, but it had been ongoing for some time, and we were kind of right in the middle of that when I got involved in January of 23.
What was the name of the investment bank that had been engaged?
So it was Loop Capital. I believe they're out of Chicago, but a national outfit who specializes in bond financings for this type of project.
Okay, and what was the debtor considering or trying to work with Loop Capital to obtain?
They were trying to, quite simply, money. They were trying to obtain money to put into the debtor through really whatever form. I mean, they were kind of specialists in bond financing, so they gravitated towards the bond markets. They're trying to get money to come in junior to the existing bondholders. Sometimes I think I even saw estimates of up to $100 million of new money to deal with both, mechanics liens are outstanding, unpaid accounts payable, and unsecured debts, as well as provide working capital for the park, because the park was continuing to lose money on a monthly basis, significant amounts of money, and the park needed a runway to get to profitability to where it could hit its projections and then start to service the debt in a number of years. And so that process was in the middle. They were, they had put together materials. They had, talked to a number of different potential investors, and we're in the middle of that process when I got involved.
Can you tell the court how that process with Loop Capital ultimately played out? Sure.
It's kind of seemed like an endless stream of conference calls, weekly conference calls or biweekly conference calls to talk about the status. The reality of it is, though, that Loop was not able to deliver any proposal that I ever saw, not even a draft of a proposal. But I'm not aware of any third party who committed in any respect to provide any new capital to the debtor under the circumstances that they were being asked to. And so in about, I would say, March timeframe, March of 23, I know we made a decision at the debtor, as well as the bondholders made a decision that this was a fruitless effort. It was a waste of time to continue. Despite Loop's best efforts and their canvassing of the markets, this wasn't going to happen. And so Loop was told to stop the activity because they couldn't produce anything, and we need to look at other alternatives, namely potentially filing for bankruptcy.
Okay, so that was about mid-March, you say?
Yes.
Okay. At that point in time, did the company make a decision to try and obtain a DIP loan?
It did.
And why did the company need a DIP loan if it was going to file bankruptcy, Mr. Brennan?
Well, we're losing $1 million a month. We knew that we would have to fund the administration of the bankruptcy, professional fees. We knew we'd have to keep everyone current in the bankruptcy and not become administratively insolvent. Despite our efforts to reduce costs as much as possible, given where the revenue level of the park was, the profitability just wasn't there. It needed more time to continue to build volume, and that was years down the road, not months down the road, and it couldn't be turned around that fast, particularly going into the summer season, which is a little bit slower, given the heat in Phoenix and the relative lesser activity here in town. And so we knew we needed money, or else this case would be DOA. We might as well, hand the keys back over essentially to the bondholders or file for Chapter 7.
Okay. You testified a little bit ago about the factors that DIP lenders look at in underwriting a loan. Given what your experience with Legacy Cares at the time, how did those factors look for obtaining a DIP loan prior to filing bankruptcy?
Not very good. We had no collateral. There was $300 million of senior bonds. They had a leasehold interest in the park. There were no unencumbered assets. Essentially, all the assets are leased. So there was no even just golf carts and equipment. None of that was even around. Not that it would provide us enough capital to operate, but there wasn't even that to work with. The land is leased under a ground lease with a third party. So there's no real estate to attach to. The park had lost, I think in calendar 22, lost $12 million before debt service. So just operating the park and trying to keep the lights on. Park continued to lose money in 23 every month, despite efforts to reduce costs. Still continues to lose money today. There's no owner for the park. It's a nonprofit. Therefore, it has no owner who could provide outside collateral, real estate, or some other net worth outside of the park's assets. That's not available because it's a nonprofit. So there was nothing, really nothing that we could offer to a lender to get a new loan, and because everything was encumbered and we were losing money, there would be no way to repay the loan, even if one was made.
So at the time, did you think Legacy Cares could obtain a DIP loan on an unsecured basis?
My professional opinion is there was no chance.
At the time, did you think Legacy Cares could obtain a DIP loan secured on a lien on unpledged assets?
Well, there were no unpledged assets, so no.
At the time, did you think Legacy Cares could obtain a DIP loan secured by a junior lien on the park assets?
No. In my opinion, no lender would put themselves behind $300 million of bond money plus potential mechanics lien claims. So now you're talking, $330, $340 million. This park was losing $12 million a month, $12 million a year, $1 million a month. There was just no way that a lender, would take a junior position because there's no way for them to get repaid, absent a sale for a number that would be totally unrealistic.
So at the time, did you think it would be possible for the debtor to get a DIP loan without offering a priming lien?
Objection. Speculation.
I think he's already qualified that he's an expert in what the factors are for underwriting for a DIP loan, and he is capable of testifying as to what his thought was at the time. He was
That's the
advising
question
the
of whether he sought priming lending
Well, we'll
from
get
some
to
other source.
We'll get to that, Your Honor. But I'm asking him did he think it was possible to obtain a DIP loan without offering a priming lien to the DIP lender?
Right, and Your Honor, I don't think Mr. Bierman's been tendered as an expert witness. My understanding is that he's here as a fact witness based on his work with the debtor. So he can't really be testifying to his opinion. He can testify to facts, but what Mr. Taylor is asking for is an opinion.
I'm not asking him to give an opinion as to what the market necessarily required. I'm asking him to state what his thought was at the time as an advisor to the debtor looking at financing in the face of a bankruptcy.
Objection sustained. Let's move on.
At some point, Mr. Bierman, did UMB Bank offer to make a loan?
Yes.
And did that loan require the offering of a priming lien?
Yes, it did.
At the time, did you think it would be possible to get another lender to come in and offer without a priming lien?
Objection. Same objection. It calls for speculation.
Essentially the same question, so objection sustained.
After the bankruptcy filing, Mr. Bierman, in May 1st, did you have a chance to talk with any other lenders about the terms of making a DIP loan?
I did.
Okay, can you please tell the bank what you did?
Sure. I contacted three what I would consider alternative lenders, Guarantee Solutions, Serene Investment Management, and Monroe Capital. I also contacted two commercial lenders, commercial banks, National Bank of Arizona and Arizona Bank and Trust, and essentially laid out the facts and circumstances of this case, both pre-petition and post-petition, and asked them if they would be interested in offering a loan to the debtor. And the answer was soundly no. No, thank you.
Did they indicate to you anything about a priming lien?
They said if they were going to make a loan, it would have to include a priming lien. Absolutely.
Let me turn your attention to the terms of the DIP loan. Can you recount for the court the basic economic terms of the DIP loan?
Sure. It's up to $9 million in total borrowing capacity. I believe the term is through September, although there are some conditions in there depending on what happens in the bankruptcy case. It's a 12% interest rate, 2% fee, I believe, based on the borrowing commitment. There's some monthly reporting, budget to actuals, and those kinds of things, but those are the basic terms. Priming lien, of course, being one of them as well.
I'd like to pull up Debtor's Exhibit 1 if we can do that. Bierman, you have in front of you what's been marked as Debtor's Exhibit 1.
Hold on a minute. I'm not getting it on my screen here.
Is it showing on any of your other screens, Judge?
Mr. Bierman, do you recognize what's been marked as Exhibit 1?
I do.
What is that?
I asked Miller Buckfire, who's the investment bank who was retained by the debtor, this was pre-petition in early April, to provide me with a list of comparable transactions based on their market knowledge and the database that they had access to, and asked them to send me some sample DIP financings that had occurred so that I could see what the terms were.
Okay. And what does this term sheet indicate as far as the parameters for those DIP loans, generally speaking?
Yeah, so there's essentially this sheet, I guess the search criteria, if you will, are Chapter 11 cases between October 1 of 22 and April 1 of 23, where a final DIP order was entered, excuse me, and that the liabilities of the case are between 100 million and 500 million, comparable with this particular case. And there's 7 transactions, 7 DIP loan facilities that they provided to me that outline who the borrower was, the case, obviously, the court, when it was entered, how much the commitment was, and then the interest rate and other costs associated with each of these loans.
And looking at the loans that are summarized here, how would you characterize the terms that were offered by UMB Bank on the DIP loan?
In a general sense, I would say that the loan offered by UMB is more advantageous than these loans. Certainly competitive at a minimum, but actually better in terms of terms, cheaper, fewer fees, a little more flexibility as far as the debtor is concerned and the borrowing capacity of the debtor from a timeline perspective.
For the DIP loan, for example, does it require an exit fee?
It does not require an exit fee, no.
Okay, but these other loans do, is that?
They do, which are, vary between, looks like 1% and 3%, depending on the loan.
As well, what about the condition of guaranteed interest?
Yeah, so that's another issue that the lenders that even I talked to said, they said, if we were to make a loan, which we're not interested, but if we were, we would require a minimum interest period. So say interest for 6 months. Because they don't want to take the risk of making a loan and earning 2 months worth of interest. So there would be an upfront cost associated with that commitment that we do not have in the current DIP facility with UMB.
And in your experience, do DIP lenders often require debt service during the term of the bankruptcy case?
They often do. It obviously depends on the case and the cash flows, but most lenders want to see some debt service so that their exposure is reduced as the case goes on.
And the DIP loan being offered by UMB Bank, does it require debt service?
It does not, no.
All right, Mr. Bierman, I want to shift your attention, if I can, to the issue of keeping the park open. We can talk about that. Prior to filing the bankruptcy, did Legacy Cares consider the option of closing the park down to save expenses?
Yes, we did.
How did you assess that option, Mr. Bierman?
Yeah, so this was in February of 23. We ran a number of analysis, including projections, essentially assuming that we would, as I call it, mothball the park. We'd shut the park down from essentially all activity and put in place, whatever costs were necessary to preserve the asset as best as we could. This is a large park. It's 320 acres, has tons of facilities, many of which are very expensive to maintain. And if you don't maintain them, the value goes down very, very quickly. So we ran an analysis, essentially said, what if we mothball it? What's it going to cost us? We prepared that analysis. We shared it with FTI, the financial advisor to UMB. They tore through it in detail. We had lots of calls about it, lots of discussion about it. They questioned all the assumptions. We responded. We had a very productive discussion with them. At the end of the day, this was in February. At the end of the day, the analysis was, and this was in the high season, okay, that it didn't make sense to mothball the park, that in fact it would cost more money to mothball the park on an out-of-pocket basis to preserve the assets than it would to operate the park and, basically fund the losses from the operation.
Can you explain to the court why it would cost more on an outlay basis to mothball the park rather than operate it?
Yes. You would essentially lose all of your revenue, right? These are tournaments, adolescents participating in practices, leagues, special events, all those kinds of things. If you mothball the park, you essentially terminate all those contracts. So you have, and those participants and those activities are responsible for paying for parking, paying for food and beverage, paying for additional ticketing for family members, buying T-shirts, buying lunch, and stuff for the kids while they're at the park. So you would essentially lose, there's no revenue generating activity that you could have at the park if you shut it down or even quasi shut it down. So you would lose all your revenue. Now you do obviously eliminate some cost associated with that, but the profit, if you will, on the activities before you get to the fixed cost infrastructure is still pretty significant from the revenue generating activities. But the real problem is you have such a heavy fixed cost infrastructure associated with this park. You have rent, you have landscaping, you have security, you have leases, you have all manner of very expensive things that need to continue to be paid even if you shut the park down and in order to be able to maintain the park. And you have to build a certain volume with the activity of the park to break even. And when you lose all your revenue, that the bulk of those costs are going to still remain, and you're still going to have to pay them to preserve their value. So you're paying them either way. You might as well have the activity there.
Pull up Exhibit 2, please. Bierman, do you have in front of you what's been marked as Debtors Exhibit 2?
Yes.
Can you take a look at that?
Yes.
I don't want you to go through the line item of this, Mr. Bierman. I think to just save time, can you explain to the court exactly how much money the park is, I guess, saving by borrowing and keeping open as opposed to being mothballed?
Yes, and just to clarify, this analysis in this exhibit is an analysis that I updated last week in advance of this hearing, using a lot of the same essentially assumptions and methodology as in February, but comparing this now to the DIP budget, right, which is the relevant budget that we're comparing it to a mothball budget. And essentially the summary of this analysis is it will still cost you, or it will cost you $3.7 million more than the current DIP borrowing, the $9 million in DIP financing, to shut down this park. So essentially by keeping this park operating, you're saving $3.7 million of additional borrowings you would otherwise need to maintain the park, primarily because of the revenue loss and the loss of the contribution of that profit to the park's expenses.
This is pre-taking on the new financing, though.
No, that includes the new financing, Your Honor. So
show me that in your model here.
Sure. So really the financing, the $9 million DIP financing is essentially, if you think of that number as that's the loss that has to be funded. Okay, so on the left-hand side of this exhibit is the DIP budget. Okay, and you can see if you go down to the very bottom here, let's see, the middle of the page, the net operating loss plus additional cash outflows. This does not include. This does include professional fees. You see a loss of $6.243 million for June to October. Okay. Then on the right-hand side is the mothball budget, and you'll see the loss is now the number on the far right side where it says difference, favorable / unfavorable. That's the favorable or unfavorable variance. So when it shows as or reflects as a negative $3.656 million, that's a loss in addition to the $6.2 million loss that you would incur under the DIP facility as an operating park. So it's incremental loss because of the loss of all of the revenue and because you are making money from what I call a contribution margin when you take your revenues less your direct expenses, namely your coaches, your referees, those kinds of expenses. Even when you take those out, you're still making, even when you pay those expenses as an operating park, you're still making that profit that then goes to pay rent and utilities and property taxes and all those kinds of things. You take that out, and all of a sudden you're just paying all your expenses with no revenue, no offset, and that's why it's $3.7 million more.
Mr. Bierman, in your experience in restructuring and bankruptcies, is there value to selling and operating business and ongoing business?
Very much so, yes.
And in this case, do you think that the value of the park's assets, the debtor's assets, are maximized by keeping the park open versus mothballing it?
Very much so. It's an analysis I've looked at several times. I've confirmed with the financial advisors for the trustee, UMB, about that issue as well. And it's clear to me, I know it's clear to them based on my conversations, that we're going to get the most money for this park in a sale if it's operating. If we maintain the personnel, if we maintain the contracts, if we maintain the condition of the park, if we maintain the reputation of the park as best we can, going dark essentially will set the value of this park back considerably, in my opinion.
What does considerably mean to you?
It's very difficult to estimate, Your Honor, but it's a lot of money. I hate to venture a guess, but it's a lot of money. Certainly much more than, in my opinion, much more than the cost of the debt financing.
Just let me put a little finer point on that. Can you explain to the court what are some of the things that, if you shut the park down, happen and to detract from value?
Sure. Well, I guess first off, you have reputational damage, right? Be in the paper, park shuts down. You would have all of these events, whether it's practices, leagues, tournaments, charity events, all of those special events, all of those would be canceled, right? So you'd have people who put deposits down who aren't going to get their money back potentially. You have a situation where once you cancel all those contracts, and their trip, gets canceled. Maybe they have, the family has airfare. They're planning on coming out for a tournament. They have to eat that. So there's a lot of reputational damage. The other thing that happens with a park like this is if you shut it down, it's going to take a substantial amount of time from a revenue perspective to build it back. You have to then, once the park, does reopen or is in a position to reopen, you don't just start with the revenue that you had when you shut the park down. You got to build that all back. And so now you've got to book contracts months out in advance. You got to get the confidence of the sponsors and the confidence of the participants that, yes, if they commit to put money down, the park will operate. It will be there for them to play. You got to commit, the sponsors will have confidence that they're going to get value for their sponsorship dollars, which are significant. The other thing that happens is there's several hundred employees of the management company that work at this park. They love the park. They're specialists in what they do. They'll be out of jobs and they will have to go somewhere else. And if you were to have a buyer, for instance, come in and try to take this park over, they would have to try to rehire all those people who are fairly specialized in what they do. They're used to working with amateur athletes and putting on these tournaments and events. It is a skill that they have, and it's an expertise that they have. You will have to try to reconstitute that workforce that was there for at least a year operating, and you probably won't get most of those people back, is my guess. You'll get some, but you'll certainly lose a whole bunch. And then of course you've got the burn, right? You've got the burn of, you got to pay the $315,000 in rent every single month. You've got to pay the leases on the scoreboards. There's still the expense of the park that you're just going to be writing checks for and not getting any return while it sits dark.
Thank you, Mr. Berman. I'm finished.
Thank you. Mr. Pack, cross-examination, please.
Good afternoon, Mr. Bierman.
Mr. Pack.
So I think I was a little bit confused about some of your testimony. I thought I heard you say that the debtor, if it gets this DIP financing, is going to be making a profit, but that's not really true, is it?
No, if I said that, it's certainly not correct, but that's certainly not what I intended to say, no.
Okay, so in your Exhibit 2, what it's showing is that if you get this $9 million loan, the debtor is still going to spend $6.2 million more than what it would spend. The debtor's still going to spend $6.2 million in expenses, more than the revenue that it's taking in, right?
If the debtor continues to operate as planned, yes, it will still lose $6.2 million during the pendency of this bankruptcy through September.
Okay, and in addition to that, in addition to losing that $6.2 million, the debtor's also going to be another $9 million in debt.
No, that's not how that works. The $9 million funds the $6.2 million. So essentially the debt funds the operating losses.
You have loan repayments figured into this this exhibit that you've prepared?
It is not in here. No, this does not contemplate sale proceeds or repayment to any creditors of any manner in this. This is kind of an operating budget.
Okay, so the debtor is still going to owe the bank the $9 million that it advanced, right?
That is correct, yes.
Okay, and in addition, it's also going to owe all of the interest that's accrued up until the loan is repaid, right?
Yes.
And the 2% loan fee that you mentioned?
If it's approved, yes.
Okay. And these projections that you've prepared, they are just projections, right? They're your estimate or opinion of the revenue that the debtor is going to get and the expenses that it's going to have to pay. It's not fact, right?
It is an estimate. It's based off of my, working with the debtor for 6 months pre-petition and my understanding of the business, my team's understanding of the business. And yes, you put together the best projections you can, not knowing what will happen, certainly.
Okay. And you had actually, I think you said you had updated this projection last week. At the time the debtor filed its bankruptcy petition on May 2nd, you had also prepared projections about how the DIP money, how the DIP loan funds would be used, and what debtors' revenues and expenses would be over the repayment term, right?
Yes.
Okay. I just want to show you that because it seemed to me that there was still a pretty significant difference between your initial projections and the projections that you presented in Exhibit 2. If I could ask Ms. Nesselrode to please pull up Mr. Bierman's first day declaration. And go to page 16. So these are the revenue projections that you prepared at the outset of the case, right?
Well, these aren't revenue projections. These are operating receipts and expenses for the projected pendency of the bankruptcy.
What's the difference?
You said revenue projections. They're not just revenue projections. This is a full budget.
Revenue and expense projections.
Correct. That's correct.
Okay. And then if we go to page 17, if I'm looking at the far right corner in that row that says net cash flow, it looks like you've projected that by the end of October of 23 that there's going to be a net loss of $8 million. Is that correct?
Yes. Could you go back to Exhibit 2 real quick? The mothball budget. I just want to look at one number because I think I can answer your question.
Okay. Go ahead. Debtor's Exhibit 2. What is it that you wanted to see?
Scroll down to... Okay, I understand. I've seen what I need to see.
Okay. It doesn't change the fact that you initially projected that the debtor was going to lose $8 million, and now you're projecting it's only going to lose $6.2 million.
That's not correct. This is the same exact budget as was in the DIP. This is for what's in the mothball budget is from June to October because it didn't make sense to have a hearing about what already happened in May. The first budget that was filed was from May to October, so you're missing an entire month of losses in the comparison. That's why the numbers are different.
Okay, well, let's look at the losses for May that you had projected. Let's go back to Mr. Bierman's first day declaration.
Okay.
And let's go to 16 again. Okay, so on this go back to, okay, this is May. So if you look at this projection, this shows the losses that you are projecting for May, right?
This has a weekly budget of losses that constitutes May, yes.
Okay, and the first 4 weeks are the first 4 weeks of May, right?
It is. It's obviously there's a few days. And this is a little bit apples and oranges because this is weekly, and we try to time the payments to when they would fall based on the week. So when rent's paid, for instance, when payroll's paid. If you're looking at a monthly, it's going to be different because the month is going to capture those expenses, but it's not going to necessarily capture the precision of a week-to-week budget. So there is a bit of a difference there from an apples to or comparison purposes.
Okay, but overall, there's only 3 days difference between a budget that shows revenues and expenses for May 1 through 28 versus a budget that shows revenues expenses for May 1 through May 31.
It just depends on when the payments fall within the weeks, Mr. Pack.
Okay, but if you look at the projections that you've got here, the first week of May, you're projecting about a $590,000 loss. The second week, $94,000 loss. So
profit
that nets out to about 500.
Profit,
and,
yes.
Week 3, you've got a $582,000 loss, and week 4, a $44,000 loss. So that nets out to roughly 540. So that's $1,040,000 in total that you are projecting to lose from May 1 through May 28th in your initial budget, right?
If you were to compare just those weeks with the full month of May, then yes, that math is accurate. But what you're missing is additional expenses and the timing of those payments in the week-to-week budget versus the monthly budget.
Okay, you haven't prepared a week-to-week budget for the use of the DIP loan proceeds, right? I mean, other than you have your Exhibit 2 doesn't reflect a week-to-week budget.
That is correct. The Exhibit 2 is just a comparison. Again, it's for different purposes. It's a comparison of over the pendency of the case, how much will we essentially need or lose operating the park versus not operating the park. So it's 5 months of activities versus week to week. So it's like I said, it's not, you can't directly compare them because this week to week budget that's up on the screen is as precise as we can make it in terms of when payments are actually made. The monthly budget was prepared first based on what's going to be incurred during that month, and then those specific payments within the month on a cash basis are then moved to the week that they are likely to be paid. So there are some timing differences. It's not a direct comparison. It's not intended for that purpose.
Okay, I mean, because the way that I looked at it is you initially projected $8 million in losses. If you back out the $1 million, $1,040,000 that you had projected for May, you'd be left with about $6,960,000 in losses, which would still be significantly greater than what you're now projecting. But what I'm hearing you say, and you can correct me if I'm wrong, is that's true, but there's a reason for it.
The losses are different. They're different periods of time, and they are different timing. So the answer is yes. Based on the comparison that you did, I can see where you're getting the difference, but the difference is explainable because of the precision of the week-to-week budget versus the monthly budget.
Okay. And I know that the deadline for the debtor to file monthly operating reports hasn't come due yet, but the debtor has not filed any of its monthly operating reports, correct?
Correct.
And those would tell us what the debtor's actual revenues and expenses were, right?
On a cash basis, yes.
But at least on the record that we have in front of us right now, because there aren't any monthly operating reports, there really isn't any disclosure to the creditors at large as to how the debtor's actual performance stacks up to your projections of how the debtor would perform. Is that fair?
To my knowledge, we've not filed anything with the court that shows budget to actual performance because it hasn't been required yet.
Okay. And none of the loan proceeds that the debtor is going to take from UMB's DIP financing are going to be used to add any improvements to the park, right?
I guess it depends on how you define improvements, but we're not planning on building anything, if that's what you mean.
Okay. So the loan isn't necessarily going to enhance the value of the park. It's just going to keep the value of the park from deteriorating. Is that correct?
I disagree with that.
And why is that?
Well, because it is going to enhance the value because it's going to continue it as a going concern. Continuing activity at the park having a reason for people to come to the park, to pay for their tournament and their practices and sponsorships, that is a real value to the DIP loan, is keeping it operating so that it can be sold as an operating park as opposed to basically just a debt facility.
Okay, but the debtor was operating on the day it filed its bankruptcy petition, right?
Correct.
And the debtor is still operating.
It is, as of today, yes.
Okay, so there's nothing about the DIP loan that's going to change the value of the park from day one of the bankruptcy and make it greater than it was on day one. Is that?
Well, I mean, I guess I still disagree with your premise. At the end of the day, I mean, advances have been made under the DIP loan. Those advances have been used to pay operating expenses of the park and fund losses at the park so that it can continue to operate. So there has been a very tangible value associated with the advances that have already been made on an interim basis under the DIP facility. That has enhanced the value of the park, in my estimation, because it's now a park that can be marketed and is being marketed on a weekly basis to buyers who can see the activity, who can see the contracts being performed, who can talk to the employees about how they operate the park, and then they can make a decision what they want to pay for it when they decide to make an offer.
Okay, so I understand the concept that by allowing the park to remain open, that maintains the going concern value of the park. And I understand you believe the park is more valuable as a going concern than if it's mothballed. But you can't actually quantify, put into numbers, the impact that keeping the park open will have on the value of the property, can you?
It can't be precisely quantified at this time because of the ongoing marketing process.
Okay. And also, you couldn't say with any certainty what the property will ultimately sell for, correct?
It will be sold for what someone wants to pay for it, and at this point we're in the middle of that process, and not all the offers are in, and I don't know what it will ultimately sell for at this point right now.
Okay. I have some questions about your mothball projection, so if we can go back to debtor's exhibit number 2. And let's go down to the next page. So this is pretty small. I wonder, Ms. Nesselrode, can you enlarge it? I'm primarily interested about in the right side of this document. Well, actually, that's not going to work because then you can't see what the expense categories are. So let's go back as far left as you can. That's good. Let's stop there. So you're projecting that if the debtor is mothballed, it's still going to spend $90,000 a month on electricity. Is that right?
Yes. Yes. Okay.
And if the debtor is operating, it's going to spend $120,000 a month in electric fees.
Yes,
right?
I believe there's a 25% savings by mothballing it. You still have to air condition the park to some degree. Like, it doesn't have to be at 72, but it needs to be air conditioned to the point where there isn't deterioration because of the hot summers here in Arizona. And you're giving tours of the park as well to prospective buyers.
Okay, you also have a line item for capital leases, macro lease, and IFS. As I understand it, that's for certain sports equipment that's leased to Legacy Cares. Is that accurate?
Partly. It's for IFS provides a lease that relates to essentially the billboards and signage, electronic billboards and signage at the park. It's quite an extensive infrastructure of electronic signs and message boards. And then Macro Lease provides fitness equipment for the park in the performance center, primarily.
Okay, and you're projecting that it's going to cost $240,000 or so more to make payments on those leases if the debtor is mothballed than if it's continued in operation?
Yeah, so the $305,000 that you see in the current DIP budget, that was when the DIP budget was prepared, that was an estimate of what we felt we could negotiate a deal with IFS and with Macro Lease. And so that number of $305,000 is comprised of two numbers: $250,000 to IFS, which they've agreed to, and we have paid, and per month, and then Macro Lease of $55,000. That's how you get to the $305,000. So both those numbers are compromised numbers based on what we thought that was a fair number to provide to them as basically as adequate protection. The amounts that are in the mothball are their full contractual amounts that are due, under the assumption that if there was no reason for them to continue to essentially cooperate with us because they didn't see the park operating and didn't know what the prospects of the park being sold were and whether a buyer would necessarily be interested in assuming those leases or not under their current terms, that they would demand full payment under their contracts.
Okay, those contracts aren't secured by any lien on the park, are they?
Well, they have whatever contractual rights they have within those contracts to their equipment, is my understanding.
Okay, so they could take the equipment back if it wasn't paid for because it's their equipment, but they don't have a lien that they could assert against the real estate, either the fee or the debtor's leasehold interest, correct?
Not to my knowledge. They have what they have in their contract.
And a new buyer, somebody who comes in and buys this park, presumably is going to have to make its own lease payments, right?
Yes.
Okay, and it can either choose to lease from Macro Lease and IFS, or it can choose to lease from somebody else, right?
They can. Obviously, there would be ramifications in terms of that lease rejection and a claim in the bankruptcy case.
Okay, so the $542,000 that you're projecting the debtor would accrue on these leases, that would be essentially an administrative claim in this bankruptcy case, right?
It could be, yes.
But not a secured claim.
I guess it maybe not secured in a sense of priority over the bondholders and mechanics lien holders potentially, but certainly secured as to their equipment.
Okay. Let me go down to the last line item that you have in this projection.
Let's see.
Keep going. Right there. So I want to look at under where it says Legacy Cares Inc. expenses. You've got a line item for professional fees, right?
Yes.
Okay. And it looks like you're projecting $1.9 million in professional fees if the debtor remains open, right?
Correct.
And I think you have the same amount listed if we can just scroll to the end if the debtor is mothballed.
I believe that's right.
Okay. But just with as with the leaseholders, those administrative claims aren't secured by any lien against the debtor's real property, are they?
Your Honor, we object to this line of questioning. It's calling for legal conclusions.
Well, he's a fact witness. He's familiar with the debtor's finances. I think he is qualified to say, as a matter of fact, whether he's aware of any liens against the debtor's real property in favor of the debtor's professionals.
With respect, that wasn't the question that was asked.
Well,
restate the question, please.
Okay. To your knowledge, do any of the debtor's professionals have liens against the debtor's real estate?
Same objection.
Overruled.
I don't know about liens per se. Again, I'm not a lawyer, but there is a carve out, I know, in the agreement. How that affects us, that's certainly for the court to decide, but there's not a lien filed, if you will.
Okay. So those two would be treated as an administrative claim, but not a professional claim. Is that correct?
Not a professional claim?
I'm sorry, not a secured claim.
I don't know how the court would view those claims necessarily, and what the professionals would what their position would be relative to the priority of their claims. The numbers are the same, given my assessment that the work would essentially be very similar under either scenario to get this case to the end.
Okay, let me move on to a different subject. As I understood the questions that Mr. Taylor was asking you, he was really trying to get at, you couldn't get financing on any better terms than UMB has offered. Is that your testimony?
Yes, and we couldn't get financing, period.
Okay, but isn't it true that UMB, the proposed lender, is in kind of a unique position in this case because it has by far the largest claim in this bankruptcy estate, right?
They are in a unique position to protect their position. They advanced more than $10 million pre-petition out of their own money to protect their position under a very similar circumstance from an operating perspective.
Okay, and if I did the math right, just very roughly, their claim at this point is somewhere in the neighborhood of over $300 million, right?
Yes.
So wouldn't it be fair to say that UMB already has the biggest stake in what the property ultimately sells for?
They certainly have a big stake, whether it's secured or unsecured, and the portions, you know, that are determined to be secured and unsecured. Yes, I mean, by absolute dollars, they are the largest creditor.
Okay. And if it is correct that UMB is a first priority lien holder, they'll be entitled to 100% of the net sale proceeds, less whatever they agreed to carve out, right?
Your Honor, we object to this line of questioning. Again, it calls for speculation, calls for legal conclusions.
He knows what the terms of the DIP loan are, and I think he's testified to his expertise, and he knows how liens work.
Are you asking the question of whether, if this DIP financing is approved, the entire $9 million plus interest is going to get paid under any scenario, that where the sale is above $9 million?
Yes.
Okay, that's pretty self-evident, isn't it?
Yeah, maybe I misunderstood the court's question. What I'm really getting at is this. Of all the people that are going to be paid from the sale of this property, UMB is going to have the largest share, right?
Again, same objection, Judge. He's asking the witness questions about a sale process that hasn't even been proposed yet. I don't think it's appropriate for the witness to speculate as to who may or may not get paid in the sale process.
Please answer the question. I'm not sure where we're going here, though.
Oh, I'm sorry, Mr. Pack. Could you just repeat it?
Yeah. When the property is sold, UMB is going to get the largest portion of the net sale proceeds, correct?
Same objection.
Overruled.
I think it depends. Obviously, it depends on what happens in this case. Depends on ultimately how the court determines, you know, where their lien is, what priority their lien is, whether it's challenged by unsecured creditors or mechanics, lien holders. There's a lot of unknowns there. Like I said, I'm comfortable saying they have the biggest dollar claim. Whether it's secured or unsecured and what priority is yet to be determined.
Okay, so wouldn't it be fair then to say that UMB has an incentive to ensure that the property sells for as much as possible, whether it funds its DIP loan or not?
Objection calls for speculation.
Overruled.
I think it's pretty clear to me that UMB, based on their pre-petition and post-petition offering of credit, is pretty convinced that this property is worth a heck of a lot more for everyone if the financing is provided and the park operates as a going concern. So yes, they are incented to keep this park operating and advancing money in that regard so that it doesn't shut down, which would reduce the value in their estimation and in mine, if that answers your question.
It does. So that incentive for UMB is there to fund this loan, whether they get a super priority lien or not. Isn't that true?
Your Honor, this witness has not been tendered by UMB. He is not a UMB employee, and he is not competent to testify as to UMB's intentions in this matter. We object to this entire line of questioning.
I'm going to just add mine that is asking for speculation, Your Honor.
All right. Objection is sustained.
Okay. You don't represent UMB, do you, Mr. Bierman?
No.
You don't work for them?
Nope.
So if and I think that the court just made this point for me, but if I were to ask you whether UMB would be willing to advance funds without a priming lien, you would be speculating, in fact, wouldn't you?
I'm sure they would not advance funds without a priming lien.
Okay, but you can't say that for certain because you are not UMB and you do not represent them, correct?
That is true. I cannot speak for them.
Nothing further.
Any redirect?
Nothing from us, Your Honor.
Mr. Riggs, did you want to question the witness?
Not at this time, Judge. Thank you.
Okay, I'm going to call your next witness then. I'm presuming that we're really only talking about Mr. Pack's client and the debtor. If there's somebody else that wants a shot at one of the witnesses, please let me know now.
Your Honor, I'd call Mr. Doug Moss to the stand.
Do you solemnly swear that the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Moss, could you please state your name for the record?
Sure, Doug Moss,
And what is your position with the debtor Legacy Cares?
President of Legacy Cares.
Do you have any other positions with the debtor?
No.
Are you on the board of directors of the debtor?
Yes.
Could you briefly summarize for the court your employment background?
I've been in the sports and entertainment business for about 40 years, starting in the mid-'80s in Madison Square Garden, where I moved on there to the Buffalo Sabres, where I was president and CEO for a few years, commissioner of the International Hockey League. Then with Disney Sports at the Mighty Ducks of Anaheim, and was president of the Phoenix Coyotes for about 7.5 years. So my background is in professional sports and entertainment.
All right, regarding your positions on the board and as president, when did you take on those roles with Legacy Cares?
February of 2020.
And were you involved with the construction of Legacy Park?
Yes.
Can you please tell the court, how were you involved in the construction of the park?
I was involved in reviewing pay applications, invoices, creating requisitions to be processed at UMB Bank to pay vendors, contractors, etc.
Now, what assets specifically does the debtor own in regards to the park?
The ground lease and the improvements, building structures on the premises.
As president of Legacy Cares, do you have an opinion as to what the minimum value of the leasehold and improvements are?
Yes.
What is that opinion?
I think at a minimum it's $50 million.
Why do you think the leasehold and improvements are worth at least $50 million?
Well, from the
Objection, Your Honor. I'm objecting to the extent he's going to testify concerning any of those documents that were submitted to the court, which again haven't been produced to us and which we can't cross-examine here.
I haven't heard anything that suggests the foundation of his opinion is based on that.
Okay. The question I just asked him, Your Honor. Again, Mr. Moss, why do you believe that the park is worth at least $50 million?
Because of the general cost of constructing the park, of the quantity and the quality of the facilities and the assets at the park as well, the attendance in 2022 and 2023, and the amount of events that are there, and the potential of what a new owner could potentially bring to the park in way of operating at a more effective and efficient level.
Now, do you have an opinion as to the specific market value of the improvements and leasehold interest of the park?
No.
Why is that? Why don't you have an opinion as to the specific value of those?
A value of a property, any properties, could differ on the company that would potentially buy it. Different, depending on their assets, their company vision, their goals and objectives, the value could change company by company.
Do you have an example of that type of situation from your own work past?
Yes. When I was at the Garden, we were owned by Viacom for a short period of time, and Viacom put us up for sale. And the ultimate buyer was eventually sold to Cablevision, which made a lot of sense, and because Cablevision had held it in a higher value because it owned hardware in its cable systems, that really made sense for them to acquire the software, the content of Madison Square Garden with Knicks, Rangers, and Yankees content. So in that way, it was much more advantageous and I think more appealing and had a higher value than some of the other potential buyers.
Now, do you recall, Mr. Moss, that you testified at the 341 meeting last week in this case?
Yes.
Okay. Do you recall that during that meeting, the attorney for Wholesale Floors, Mr. Pack, asking you this question, and I'm going to quote it, "What is your opinion of the value of the property of Legacy Cares owns, including the value of the leasehold interest and improvements?" Do you recall that question from Mr. Pack?
Yes.
Do you recall what your answer was?
Yes.
What was your answer?
I don't know.
What was your understanding of what Mr. Pack was asking you about in that question?
Basically, I took it as what is the sale price? What is the sale price going to be? Trying to project as to an opinion as to what it's going to go for, the value. That's how I took it.
And why did you say you didn't know what that ultimate sale price would be?
Because I don't.
Let me change the focus here, Mr. Moss. I want to talk about when construction began on the property, if we can do that, okay? Again, when did you become involved in the construction of Legacy Park?
Just after the groundbreaking.
Well, you said, though, that you were president back in February of 2020. Is that correct?
That's correct.
So you were actually involved in the planning and development of the park somewhat prior to September of 2020. Right?
Yes.
Okay. When was the first work done on the project? Well, let me rephrase that. What would have been the first work done on the property in constructing the project?
Was some demo and clearing of the property to hold the groundbreaking ceremony.
So, do you recall when that first work was done on the property?
It was approximately sometime in early September, prior to September the 14th.
And what's the significance of the September 14th date, Mr. Moss?
And that was the day of the groundbreaking ceremony.
Was there any work done on the property prior to September 2020?
Not to my knowledge.
Who, do you recall, did the work in preparation for the groundbreaking ceremony?
Rummel Construction.
What debtors exhibit 3, please? Mr. Moss, on the screen in front of you is what's been marked as debtors exhibit 3. Can you please take a look at that document? Are you familiar with it?
I am.
Okay. What is that document we're looking at?
It's a project fund requisition certificate that I created.
Okay. And what was the purpose of this project fund requisition certificate?
Well, we had a process on how to pay vendors and contractors for work being done, and it would go through the process of the manager's program manager reviewing them and signing off on it, then going to an independent construction monitor, and then who recommended whether to pay or not pay the invoice. And this is the one for Rummel Construction for the work they did at the park to clear the ground for the groundbreaking ceremony.
Okay, and that's a document that you signed and dated October 22nd, 2020, is that right?
That is correct.
Okay, and what's attached to that document, Mr. Moss?
It's an invoice from Rumco.
Okay, and what does this invoice reflect? Well, first of all, what's the date range on that invoice, Mr. Moss?
Date range is 9/1/2020 to 10/20/2020.
Okay, so this appears to reflect work that was done by Rumco during that date range. Is that correct?
That's correct.
Right, and does this reflect the work that was done for the groundbreaking ceremony?
Yes.
Okay. Their Exhibit 6. Right, Mr. Moss, I've pulled up for you here what's been marked as Wholesale Floors Exhibit 6. Do you recognize that document?
Yes.
What is it?
It's the pay application for Waltz Construction, pay application number 1.
Okay, who is Waltz Construction?
Waltz Construction was the original general contractor on the Legacy Park project.
Okay, so they were the original contractor, is that correct?
That is correct.
And what's the date period covered by this pay application?
It is 9/1/2020 to 10/31/2020.
So that reflects work that was done between those dates. Is that your understanding?
Yes, it is.
Why don't we go forward there to, I believe it's the 5th page of this. Do a couple more. There, stop, right there. This appears to be page 12 of that document. Do you see that, Mr. Moss?
Yes, I do.
What is that? What is that document in front of you?
It's a proposal for work to be performed from Rummel Construction.
Okay, so this is Rummel Construction, what we were talking about before?
Yes, sir.
All right. And what is the date of this document?
September 11th, 2020.
Okay, and does this document say that it's a proposal of work to be performed? Is that correct?
Yes, it does.
And what does it reflect of the work to be performed?
It says right on there, the groundbreaking ceremony.
I have no further questions at this time, Your Honor.
Cross-examination.
Mr. Moss, you are aware that Wholesale Floors filed a claim in state court in which it asserted that its lien has priority over UMB Bank's lien.
Yes.
Okay. And that case was recently removed to this court, but as of today, no court has made any determination as to whether the mechanics lien holders have priority over UMB's deed of trust or not. Isn't that true?
I believe so.
Okay, and I believe you said in your declaration that the mechanics lien holders' claims total somewhere in the neighborhood of $37 million. Is that accurate?
Yes, it is.
Okay, so if UMB gets a priming loan for $9 million, that allows it to jump ahead in first priority over everybody else, then even assuming the mechanics lien holders do have a first priority lien, they're only going to get paid if the property sells for something more than $46 million, plus whatever interest has accrued on UMB's loan, right?
I mean, you're telling me that, or you're asking me that?
I'm asking.
I'm not sure. I don't know that for a fact.
Okay. If we assume that the mechanics lien holders have a second priority behind that first round of financing provided by the UMB bonds, they're going to be behind a loan with a balance of $266 million. Is that correct?
I think that's the correct amount of the loan, but whether they're behind or in front, or I don't know.
Okay, but if they were behind that $266 million, then in order for them to recover anything from the sale of the property, the property would have to sell for the $9 million in new funding plus the $266 million secured by UMB's first deed of trust, right?
I mean, I'm not a bankruptcy lawyer. I don't know.
Okay, but I mean, you can do math. I mean, it's...
I could do math, but you're telling me how the priorities are. I'm not aware. I mean, I don't know bankruptcy law.
Okay, fair enough. You also don't know what the property will sell for, right?
That is correct.
And when I asked you at the 341 meeting, what is your opinion of the value of the property? Is it now your testimony that you thought I was asking you, what is the property going to sell for?
Yes.
But when Mr. Taylor asked you, what's your opinion of the value of the property, then you could say confidently it's at least $50 million.
Well, that's not the question.
Objection. That mischaracterizes my question.
Rephrase the question, please.
Is it now your testimony that your opinion of the value of the property is at least $50 million?
Is it now my opinion? Could you please repeat that question? I'm sorry.
Is it your opinion that the value of the property is at least $50 million?
Yes.
Okay, but when I asked you at the 341 meeting, what's your opinion of the value of the property, you told me, I don't know.
That's correct.
Okay. And you're not a licensed appraiser, correct?
I am not.
And you're not a licensed commercial real estate broker.
That is
right?
true.
And you said that your opinion of value was based in part on the amount of money that went into building it, right?
Partially.
Okay. And we know that that amount was somewhere around $300 million, right?
No. It was about $200 million of construction. They're not including soft costs.
Okay. So do you believe the property is worth at least $200 million?
I don't believe it's worth at least $200 million, but I don't know. I mean, I don't. It could be, it may not be. I don't know.
So you don't know that the cost of constructing the property is necessarily related to what a buyer might ultimately pay for it, do you?
Well, I think in my answer I said it was the cost of construction because of the amenities, the quantity and the quality of the amenities that were paid for by the construction budget.
Okay, so it was the cost and the quality of the improvements.
That is correct. That's what I said, yes.
Okay. And aside from the cost of construction and your opinion of the construction quality, and aside from any of the offers that were submitted that haven't been disclosed, do you have anything else to base your opinion of value on?
On the attendance of the amount of people that have come to the park, the amount of events that are booked and how long they're booked for. Those are all contributing factors.
Okay. I want to shift back to talking about the issue of lien priorities. And you told Mr. Taylor that, as far as you know, no work was done on the property until the groundbreaking ceremony in September of 2020. Is that correct?
That is correct.
And when I asked you at the 341 meeting whether you were the person who had the most knowledge of when construction began on the property, you told me that you were not. Isn't that true?
If I recall the question, I think you asked who else would be qualified to offer the opinion on that. You didn't say if they were better than me or that would have better knowledge. I think you asked who else would have knowledge. I may be wrong in that, but I believe that was it. That was the question.
Okay, well, let's just play it back to be certain. Can you play the clip? It's Miller 1.
Moss one?
Moss 1, my apologies.
Recollections to your knowledge, not just a recollection, to your knowledge, was any physical construction work performed at the complex prior to the groundbreaking ceremony?
To my knowledge, absolutely not.
Is there anyone who would have better information than you about that?
Again, you could talk to Legacy Sports as the developer of the property.
And who would be the best person who would have the knowledge of whether or not physical construction work occurred prior to the groundbreaking ceremony at Legacy Sports?
I think either Randy or Chad Miller.
Okay, and I apologize. That wasn't my question. I believe that was another attorney's question. I don't remember at the moment who it was. Let me move on and ask you about some of our efforts to try and ascertain when the first work was done. You're aware that we had served discovery requests on Legacy Cares in relation to the DIP financing motion, correct?
Yes.
Okay. And let me just pull up those discovery requests. It's WF4. So if you can go to page 6. And go down. A little bit further. Okay. So, for example, I just want to give an example of some of the things that we had asked. One was identify the first date on which labor was commenced or materials were commenced to be furnished to the property in conjunction with the development or construction of improvements to the property. Is it your understanding that debtor's position was they are not going to respond to that question before today's hearing?
Objection, Your Honor. He's a lay witness. This is regarding discovery that we haven't responded to yet, and this court was well aware the time for doing so hasn't even arrived.
He knows what their position was. He's a representative of the debtor, and he knows whether they agreed to respond to that prior to today's hearing or not.
Please answer the question.
I don't know. We haven't discussed it.
Okay. And let me scroll down to the next page where we had asked for some documents. A little too far. So, for example, we had asked for contracts between Legacy Cares and third parties, all pay applications, and all payments made by Legacy Cares to anyone concerning the development or construction of improvements to the property, including the date of the payment. If I were to ask you, is it the debtor's position that they would not respond to those requests prior to today's hearing, would your answer be the same as my previous question?
Objection, Your Honor. I don't even know what that question means.
Well, okay. Let me rephrase that then. Is it the debtor's position that they would not respond to these requests for documents prior to today's hearing?
Never heard that from my counsel at all. No. The answer is no.
Okay.
Mr. Peck, we're almost at 5 o'clock. Those sitting in the benches might want to go over time, but I can pretty sure that Ms. Bryant and Ms. Bellino don't want to either. But what I see here is now basically your effort to try, if you will, the lien priority issue. And I'm not going to resolve that today. I think I made that pretty clear before. I've got two things I need to decide today. Did they shop this adequately, and what's the adequate protection situation? And this line of inquiry is not going to either one of those issues.
That's fine. I mean, Your Honor, my point really was that there's at least a question as to what the lien priorities are and that they have not been resolved yet. So
I think
in light of that,
we can stipulate to that, can't we?
I'm sorry?
We can stipulate that that's a controversy that hasn't been resolved yet.
Then that's fine. And if that's the case, then I have no further questions from Mr. Moss.
Okay. Mr. Moss, you can step down unless Mr. Taylor's got something more for you.
No, Your Honor. Thank you.
Mr. Taylor, is there anybody else you're going to be calling here?
No, no further witnesses for us, Your Honor.
Okay. Mr. Pack?
We rest as well. We have no witnesses.
Okay. All right. Is there anybody else who would like to make any comments before I make my ruling here?
If I may, Your Honor. I don't know the point, but from the committee's perspective, the court is exactly right. There are two factual issues before the court. First is whether the DIP terms have been adequately shopped. The second is whether there is adequate protection for anybody claiming to be a secured creditor here. We heard uncontroverted testimony from these witnesses today on both of those issues. There is no countervailing indication of anything indicating that the answer isn't yes to both of those. The adequate protection has been demonstrated by Mr. Moss's testimony that he believes that the property is worth at least $50 million. If that is true, then the math that was done in front of the court can do it itself. If that is true, then by all means, even if Mr. Pack's position turns out to be correct, which the court is not discussing today and not deciding today, but even if he were correct that all of the lien holders have some sort of priority above UMB's lien, even assuming that to be true, a minimum value of this property of $50 million would adequately protect them. So that means that their interests are adequately protected even if they have them. Second is that there is uncontroverted testimony from Mr. Bierman that this debtor in possession financing was adequately shopped, and despite all of the objection to his testimony, it was clear and uncontroverted that that is true as well. So from the committee's perspective, this has been a useful exercise to establish the burden of proof that the debtor has on approving the debtor in possession financing, and the committee respectfully urges the court to approve it.
Thank you. I do have one question. I want to make sure I understand this, and maybe somebody can bring up what I think is identified as Debtor's Exhibit 2 and go to the bottom line here. Okay, so what I'm looking at are two numbers here. Now, let me see if I've got the right line here. was going to compare the 9 million that this spreadsheet shows as a loss if we mothballed the property versus the 6 million, and I'm not seeing the $6 million number now if it's operational.
It needs to be zoomed out, Your Honor.
It needs to go to the right.
I can see that there, but now I'm looking at Debtor's Exhibit 2 in the exhibits that were sent to me today, and I'm not seeing that exact same $6 million number. Okay, so let me disregard what was emailed to my office today and see if we can just look at the bottom line in this. So let's scroll all the way down if you would, please. The DIP financing comes in all the way to the bottom, please. Okay, now I'm not seeing that $6 million loss if there is ongoing operations with DIP financing.
I think it's on the first sheet.
Yeah,
Your Honor, I've got a paper set if it would be helpful.
I'd like everybody to see this, but
Your Honor, just a bit of explanation. That what you were just seeing at the very end of that exhibit
That's what I had.
is not a comparison. That is the DIP budget, right?
so what page is the
I
comparison?
believe that's on page 5 of the page 5 of the exhibit.
Page 5 of the PDF?
Yeah.
Okay, thank you. Okay, there we go. All right, so when I questioned Mr. Bierman about this, he said that if we mothball this property, we're going to have a $9.9 million loss. And if we do the DIP financing, there will be a $6.2 million loss, essentially. But my question to him was, yeah, but what about the $9 million that comes in? And he said something to the effect, well, that's factored in there. But then in subsequent questioning, I got the impression that no, in fact, when you get the DIP financing and you run the operation, you experience a $6.2 million loss as compared to 9.9. However, now you owe $9 million on top of what you owed before you started. Right?
Would you like me to answer that, Your Honor?
Yes, Mr. Berman. You're still under oath, of course.
Okay, thank you. And just to clarify, so this is June to October. The original DIP budget, the $9 million is based on, is May to October. So it's an additional.
I got that.
Okay, so that's why it's not showing as a $9 million loss in this analysis because of that. So what this reflects is that if you operate it as a going concern, you lose $6.2 million.
Right.
That $6.2 million is funded by the $9 million loan.
Right.
Okay.
So you're in fact not going to have a big hole of 6.2. You're actually going to pay for that with your $9 million.
Absolutely, Your Honor.
But now you owe the $9 million.
Correct.
And you've got just short of $3 million in cash that's still should be around or still have availability.
Remember May, we have to
Okay.
we had to fund all the expenses of May too. So the answer is no. There won't be any money left around.
So this is really my question then. If what you're really telling me is you need to compare 9.9 to 6.2, and the difference is 3.7.
Yes.
Okay, you're 3.7 to the better if you just keep this thing operational.
Yes, Your Honor.
Except for the fact now you have a $9 million debt. So don't you
But
then
you're-
need to take $9 million minus the 3.6 improvement, because isn't that net a 5.4 negative?
I guess the way I look at it, if you shut the park down, you're still going to have to fund these expenses.
Right.
Someone's going to have to pay that, or that's going to be a claim in the case that has to be paid one way or another. So you're either resolving it by paying using the $9 million to resolve it, or you're resolving it as far as additional claims that need to be paid out of the case in terms of the loss on a mothball scenario.
I hear what you're saying, but I don't think you're answering my question.
Okay. Maybe I don't
Because what
understand.
I see happening here is you're comparing 9.9 to 6.2, and you're 3.7 to the better if you just keep this thing open.
Yes.
But because you now have a $9 million debt that you incurred to get to that 6.2 loss, don't you have to take the 9 million minus the 3.7 that is to the better, so that net the keeping the operation open is actually 9 million minus 3.7, or 5.3 negative. And so net, isn't the keeping the doors open going to produce a negative of 5.4 or 5.5? Or maybe it's 5.3.
I guess in my view, it's not going to create a negative by keeping the doors open. You're going to have to fund less to preserve the value of the park if you keep it operating.
Well,
if you don't keep it operating, you're going to essentially have to fund more to pay those expenses of the mothball.
Well, but who's going to fund it? It's going
That's
to be
true.
a bigger claim as an administrative claim in the bankruptcy.
That is true.
Right.
Yes, Your Honor. If it's not paid, it's not paid.
UMB may not pay for it. They might, but Mr. Pack is trying to persuade me that they're going to volunteer to pay for it because they can't afford not to.
Yes, they would have to be paid by some other source, potentially. Yes.
Right. So the way I look at this as a net, if there's really a 5.3 negative by keeping the doors open and getting this actual financing, you have to compare that to what the loss is going to be in the value of the property if you shut it down.
I could see that being a relevant analysis, yes.
Okay. And your testimony to me was to the effect of the magnitude of the loss you're going to have in the value of this property. You didn't use the word catastrophic, but that was the impression you gave me. It's going to be dramatic. And is it fair to say it's going to be far in excess of 5.3 if that is really the differential between keeping it open and mothballing it?
In my opinion, Your Honor, yes, it is. It's going to be significantly more than that.
Okay. In fairness, Mr. Pack, feel free to cross-examine him on that point.
Well, I don't have any cross-exam questions for that. I might have, in fairness, objected to the questions being calling for speculation, but I suspect you're not going to overrule yourself.
I actually have before when Mr. Carmel did that one time too. Okay. Well, thank you very much for that. So let's get to the finish line here. First of all, I made it crystal clear, I hope, that I am not resolving at all today the question of who has priority, whether the testimony that I heard today is enough to persuade me that the ground didn't break until after September 1, and therefore there's no chance the material min liens are ever going to go ahead of the bank. I have no idea. We've got another day for that, and it's probably not going to be for some time. I guess what is clear, at least from Mr. Bierman's declaration, and this is what he says at paragraph 24, the debtor's assets are severely underwater. He goes on to say that while the debtor has not appraised these assets, both the debtor and UMB recognize that the debt owed to UMB on its pre-petition loans is several multiples of the combined value of the assets. Plus, we're losing $1 million a month. So at least the debtor and UMB come to this court saying, if you just look at the UMB debt, this is underwater. And if the UMB lien is underwater and is in first position, then it certainly looks to me as if the material men are out of the money in that scenario. But the other scenario that I'm sure I'm going to hear about someday is, no, there's a break in priority, and was it $38 million is the max of material men claims that Mr. Moss testified to?
I believe it's $37 million on a face amount basis, Your Honor.
Okay, $37 million face amount. Debtor thinks it's going to actually be less than that. But if it is in first position ahead of UMB, then I really need to think about, by putting 9 ahead of 37, what am I doing to the equity cushion or to the adequate protection position that the material men liens would be entitled to in that scenario? Again, another issue for another day as to what the value of ultimately this property is going to be. I completely understand that that's going to be left to the marketplace, and my hope is that sometime soon we're starting to see what the market is going to say. I understand that we're not talking about who's actually in first and who's in second at this point. I'm not resolving that, and nothing that I say today should be construed to suggest that the material men are winners or losers in that fight. All I'm here to decide is what 364D tells me to decide in a debt financing request. And I'll address the first one, and that is that the debtor in possession has to prove to me by a preponderance that is unable to obtain such credit otherwise. And Mr. Bierman testified that not only was there an investment banker that was out shopping for money before, well, I guess October or even before then of 2022, and that they were unsuccessful in doing so. He himself went to three, I guess I would call them unconventional lenders and two conventional lenders, and nobody was prepared to come forward, and everybody said that at a minimum, even if they were willing to, and they're not willing to, they would want a priming position to do that lending. So that really was the point at which the negotiations began with UMB, and the deal is the deal that UMB has agreed to here. I'm persuaded that some of the terms that UMB has are perhaps better than market, with no exit fee and no debt service during the time of this loan until it matures. Whether it's a great deal in the marketplace, whether it's a loan that really ought to get 2% and as a fee and another 12% on interest. I guess I would say the market has spoken, as while I don't think that the debtor has an obligation to scour the entire market, they have to make a good faith effort. I think they've done so, and they've demonstrated to me that they have been unable to obtain credit other than what we have on the table now with UMB. So I think that first prong has been satisfied, and I haven't really heard any meaningful suggestion that they hadn't. So then the real controversy is more about the adequate protection piece, and what I have heard here today as uncontroverted evidence from Mr. Moss, and I think being the principal of the debtor, or the least person who's been called forth by the debtor to give the debtor's opinion here, he can't tell me what this property's worth. I get that, and he's resisted doing so, and the debtor has resisted doing so in discovery disputes here today, or even before today. But what he did tell me is he's been in the sports world for a long time in a lot of different capacities, and that based on what he's seen both in the dirt here, what has come out of the ground, and what operations are, that in effect he can't envision this property going for less than $50 million. And so whatever the material minimum liens are, they're no bigger than $37 million, and $9 million ahead of that would still leave an equity cushion if the material men are successful in persuading the court that they in fact are ahead of the UMB position. So I think that under that scenario, the debtor has carried its burden of proving to me by a preponderance of the evidence that the material men positions, if in fact they are ahead of UMB, something I haven't decided, are still going to be and are adequately protected. The reason I was asking the question about what do we have net if we continue the operations versus mothballing the operation, and I see this as really you're going to have an additional $9 million of debt on top of a $6 million loss, but that $6 million loss is going to be funded by the $9 million, but you're still net down as compared to mothballing by $5.3 million. And I'm persuaded by the testimony of Mr. Bierman and Mr. Moss that if you shutter this thing, you're going to have a much more significant loss than that $5.3 million. I'm persuaded that this property going dark, while maybe not catastrophic, is going to significantly affect the value of the property. Could it bring it below even the $50 million number that Mr. Moss came to me with today? I don't know, but I'm persuaded that this place needs to stay open, even though it's at $1 million burn a month right now. So with that, then, Mr. Taylor, I'm going to ask you to circulate this form of order that you've sent to me today, And I want comments from the U.S. Trustee's office and anybody else in the courtroom who comes to you and says, please give me a copy. Because I want to sign this as soon as possible. I want everybody to have a chance to actually see what the bells and whistles are here. Okay.
Just on that score, Your Honor, is it acceptable to the court that if I lodge the order, I will have, that's my representation that everybody has been consulted on that? Because getting people to sign off on it might be a little cumbersome.
Understood, and I think that's a fair point. First of all, can you get this out to everybody even yet today?
I believe it has been circulated to all counsel for everybody who filed an objection to our motion, Your Honor.
Okay, then can I have everybody here give Mr. Taylor their comments to the order by the close of business tomorrow? Does anybody have a problem with getting that done?
No, Your Honor. The U.S. trustee has no problem.
Okay. Then, Mr. Taylor, you're going to incorporate whatever comments you can or are willing to incorporate, and you're going to lodge it with me, I presume, on Thursday?
Yes, Your Honor.
Okay, so please, when you do lodge that order, I'll take that as the representation that everybody who's anybody here has seen it, has had an opportunity to look at it, perhaps has gotten to you, and this is what the debtor and UMB are willing to live with, and then submit it to the court. Contact Ms. Bryant when it comes in, if you would, please.
I'll do that, Your Honor.
Okay, so that puts us at Thursday morning. That's the bar convention day, but I'll be in Tucson, but can still get this thing signed.
Bar convention is this Thursday?
I'm sorry?
Bar convention is this Thursday?
Yeah, Thursday. Well, the bankruptcy piece is Friday, but I'm going down there on Thursday. While we're together, Mr. Taylor, is there anything else that we need to be talking about?
No, Your Honor, I don't think so.
Maybe you didn't hear me. Mr. Taylor, is there anything else that we need to be talking about here?
I don't believe so, Your Honor. Thank you.
Mr. Pack?
No, I appreciate the court's time and the time of the court staff, especially staying after 5 o'clock today.
Okay.
No, Your Honor.
All right, very good. We're adjourned. Thank you.